In the forging of the United States government, the Founding Fathers based the government of the new nation on a fundamental law that embodied the ideals and process by which society itself would be held together. This fundamental law is the U.S. Constitution, which was ratified by the states in 1789. The delegates who went to the Constitutional Convention in Philadelphia drafted a document that replaced the Articles of Confederation. Alexander Hamilton believed that each of the branches of government should be supreme within their own spheres. Since 1789, facets of the government have evolved due to the way that these three branches have exercised their individual supremacy, subject to the decisions of the Supreme Court, which assumed early in the 19th century the authority for reviewing all government actions and laws in the context of their constitutionality. This means that the court has functioned over time as the principal interpreter of the meaning of the Constitution. In general, the court has looked at the Constitution from many perspectives, such as the original intent of the creators of the Constitution at the time of its framing, as well as how an average citizen would today interpret the words or text of the Constitution. When the Supreme Court began, the Chief Justice was John Jay, yet at this time few important decisions were made. It was not until the beginning of the Marshall Court in 1801 that the true power of the Supreme Court was revealed. Although the power of judicial review had been intended by the framers, it was not until the case of Marbury v. Madison that it was fully realized. This case resulted from a petition to the Supreme Court by William Marbury, who had been appointed by President John Adams as Justice of the Peace in the District of Columbia, but whose commission was not subsequently delivered. Marbury petitioned the Supreme Court to force Secretary of State James Madison to deliver the documents, but the court, with John Marshall as Chief Justice, denied Marbury's petition, holding that the part of the statute upon which he based his claim, the Judiciary Act of 1789, was unconstitutional. The Marshall Court is also well known for formalizing the principle of national supremacy in the case of McCulloch v. Maryland. John Marshall was then succeeded by Roger Taney, who is best remembered for his landmark decision in Dred Scott v. Sanford, in which he declared that the people of African descent imported into the United States and held as slaves, or their descendant, whether or not they were slaves, were not protected by the Constitution and could never be citizens of the United States. It also held that the United States Congress had no authority to prohibit slavery in federal territories. The court also ruled that because slaves were not citizens, they could not sue in court. Lastly, the court ruled that slaves, as chattel or private property, could not be taken away from their owners without due process. Probably no other decision made by the Supreme Court has ever had such a great impact on the history of the U.S., and this impact culminated in the commencement of the Civil War. Later, however, Taney's decision was overruled by the implementation of the 13th and 14th Amendments. Although these are only a few of the cases decided by the Supreme Court, countless others have been taken. In the landmark case Plessy v. Ferguson, Homer Plessy boarded a rail car reserved for whites and was asked to leave even though he was only 1/8 black. In 1892, Chief Justice Fuller ruled against Plessy 7-1. This established the doctrine of separate but equal. This case would eventually be overturned by the case Brown v. Board of Ed. A little girl was forced to walk across town through dangerous areas to get to a colored school. Even though there was a school right next door, she was not allowed to attend it. This case would pave the way for civil rights and integration for African Americans. Beyond these pivotal decisions, the Supreme Court has also taken many cases on the Establishment Clause of the First Amendment. Although not strictly related to religion, Gitlow v. New York established the doctrine of incorporation, under which provisions of the Bill of Rights were deemed to restrict the state, which proved to have a major impact on First Amendment cases in later years. Since state laws now had to account for the First Amendment, all public facilities had to provide for the separation of church and state, which became an issue in Engel v. Vitale, 1962, in which the court declared that officially sanctioned prayer in public schools was unconstitutional under the First Amendment. Similarly, In Abington School District versus Shemp in 1963, it struck down mandatory Bible readings in public schools. Through subsequent cases, the role of prayer in public schools became increasingly limited. In Wallace v. Jaffrey in 1985, the Supreme Court ruled Alabama's law permitting 1 minute for prayer or meditation was unconstitutional. Then, in Lee v. Weissman, 1992, the court prohibited clergy-led prayer at high school graduation ceremonies. And finally, in Santa Fe ISD v. Doe in 2000, the court extended the ban to school sanctioning of student-led prayer at high school football games. With several precedents set, today's case of Freedom from Religion v. New York will be a major turning point for religion's place in public places. The remedy sought by the plaintiff of having the concept of God removed from all public places will be decided with the utmost care of today's court.